In the wake of the First World War, Germany faced a crisis of fate. They had been defeated by their enemies and were forced to sign a punishing treaty at Versailles. While the Allied powers rejoiced in their victory, content that they had brought the aggressive Germany to justice, their oversight in the target and application of justice eventually led to the loss of millions of lives. In the treaty, the Allied powers had punished the German government for its role in waging aggressive war, leaving the individuals responsible for the actions of the state outside the scope of punitive justice. As a result of the Treaty of Versailles and the defeat in the war, Germany was left in a supremely vulnerable position. The years of combat left families torn apart and desperate, infrastructure was in shambles, and millions of German men had been brutalized, that is to say, made brutal, by the ferociousness of trench warfare. These hardships were only made worse by the economic depression that followed. Germany was left broken, defeated, jobless, and without hope. Adolf Hitler recognized the vulnerability of the German people and took full advantage. Hitler made promises of prosperity and renaissance for the German state, as well as promising to punish Germany's enemies and to rid the nation of malignant factions. Within a few years of taking power, Hitler had accomplished the economic revival that he had promised. He had rebuilt the military. He had restored Germany as a world power. One by one, the nations surrounding Germany submitted to Nazi rule, and the Reich's dominance of Europe seemed like a foregone conclusion. Then it all came crashing down. American and Russian forces overwhelmed the German battle lines and pushed the Wehrmacht all the way back to Berlin, where what was left of the Third Reich submitted to the Allied forces. The end of the war had finally come, but it revealed one of the most horrifying events in human history. On top of the tens of millions that died as casualties of the war, the Nazi government had undertaken the systematic slaughter of millions of Jews, Romani, homosexuals, clergy, and intellectuals. Timothy Snyder claims that the figure is close to 10.4 million, 5.4 million of which were Jews. Germany had once again been brought to ruin, but this time it was clear to the Allied powers that the subjugation and sanctions of the German government would not suffice. Individuals must pay for these crimes. Problems of how to prosecute the Nazi war criminals quickly arose. Who should be brought to trial? In which country should they be brought to trial? With what crimes will they be charged when their nation has no such laws? The question of who should be brought to trial, there were wildly disparate views. U.S. Secretary of Treasury Henry Morgenthau expressed his view that the German people were wholly responsible for the atrocities, and that the Rhineland should have been fully annihilated and reduced to an agrarian state of poverty. President Truman dismissed this view, arguing that to do so would be no better ethically than lining up the German people and executing them via firing squad. Instead, he argued, the Nazis who pulled the strings, manipulated the German populace, crafted the mechanisms of genocide, and devised the battle plans were those who should be brought to trial. Eventually, the United States, France, Britain, and the USSR came to an agreement on a list of 22 names. After U.S. legal experts consulted with their counterparts in Britain, France, and the USSR, it was determined that the trial would be held in the birthplace of Nazism, Nuremberg. The American, French, and British jurists agreed that the most important aspect of the trial was that it be conducted in a just manner, as a Stalin-esque show trial would appear to be only an exercise of childish vengeance against a defeated state. To prevent this, the four prosecuting nations decided that the trial would use a hybridized system, including a tribunal of judges following the continental tradition of justice, and an adversary system in accordance with the Anglo-Saxon tradition of jurisprudence. General Stimson, Truman's Secretary of War, argued that the trial would stand as a beacon of morality and set the precedent that those who wage aggressive war and commit atrocities would be brought to justice no matter the laws of the nation whose banner they raised. In order to accomplish this daunting task, Truman appointed Supreme Court Justice Robert H. Jackson as the chief U.S. prosecutor of the trial. The first issue Jackson faced was to build a foundation for his case against the accused. The men accused had not themselves pulled any triggers, arrested any dissidents, or marched any prisoners to their deaths. They had not broken the laws of Germany. They had not broken any enumerated law so far as the justice could tell. From the standpoint of a legal positivist, they had been following the law of their sovereign, and that sovereign just so happened to be one of the most evil men in history. To solve this problem, Justice Jackson enlisted the help of legal scholar Murray Bernays, who was himself instrumental in the design of the court. Bernays designed a theory under which the Nazi officials could be prosecuted that he termed the conspiracy theory. His theory was that the Nazi government was not a legitimate government, but a criminal conspiracy designed to steal land, sequester wealth, and exterminate Jews and other ethnic groups. Those who stood accused at the trial had not, therefore, been acting as officials of the state, but as members of a criminal organization. Energized by the prospect of bringing the Nazi war criminals to justice, Robert Jackson showed little humility in declaring the moral superiority of the court, stating that 4 great nations, flushed with victory and stunned with injury, stay the hand of vengeance and voluntarily submit their captive enemies to the law is one of the greatest tributes power has ever paid to reason. It soon became apparent that the men being tried were not to be taken lightly. Most of them came directly from the Nazi high command, and the IQ tests the court administered revealed that their average intelligence was nearly 2 standard deviations above the mean. Additionally, in order to preserve the fairness and integrity of the trial, the accused were allowed to appoint their own lawyers. Suffice to say, the attorneys they chose were far more fastidious than the prosecutors had expected. Hermann Göring was the highest-ranking Nazi official on the trial. As Reichsmarshal, Göring was second in command to Hitler, and as commander of the Luftwaffe and the Gestapo, he was implicated in the worst of the Nazis' atrocities. Being the highest-ranking and most aggressive man among the accused, he quickly took the lead of the defense of his fellow imprisoned countrymen. The defense immediately began the trial by claiming that any punishments the court imposed on the accused, especially those for the charge of waging aggressive war, would be ex post facto. In other words, since there was no international law against waging aggressive war, it would be wrong to punish the German officials on trial as if there had been. British prosecutor Sir Hartley Shawcross quickly replied with the argument that the first murderer would have made the same argument, but he should have been punished nonetheless. Here, the German defense lawyers took a legal positivist approach to law, arguing that if the law was not enumerated and enforced by a sovereign entity, then there was in fact no law of which the Nazi officials stood in violation. The prosecutors, on the other hand, made an argument from natural law theory, as Sir Shawcross's analogy to the first murderer implies that there are laws that transcend those that are enumerated in legal statutes, of which one can be punished for violating nonetheless. The traditional concerns for an ex post facto legal argument did not apply in this case. The accused Nazi war criminals knew what they had done was wrong, and the court intended to prove it. To follow Shawcross's argument, examine the biblical example of the first murderer, the story of Cain and Abel. According to the story, Cain killed his brother Abel in an act of envy and rage. He betrayed his brother's trust and murdered his kin. There was, just as Sir Shawcross pointed out, no law against murder in the story. Only Cain's inborn right reason and free will were present to guide him. Aquinas argued that our inborn reason and free will were the natural precepts in which human law is rooted, and that even though something may not be illegal in the strictest sense, there are still natural laws and eternal laws that can be violated. Cain is an obvious example of someone who, according to the story, violated natural law by murdering his brother Abel and betraying his family. God quickly punished his offense, being 2 of the gravest to human morality, when he doomed Cain to exile. The offenses of the accused Nazi war criminals were similar in nature, as their actions had led to the deaths of over 20 million people, and they had betrayed their country in the process. It may seem, given the comparison to the biblical Cain, that the court at Nuremberg had overreached in their seeking of the death penalty against the accused, given that Cain was not killed but merely sentenced to exile. On the contrary, the death penalty was an exercise of mercy for those on trial at Nuremberg given the accusations they faced. Cain was sentenced to exile because it was the worst possible punishment for the worst possible crime. To be entirely outcast from society for betraying his family and murdering his brother who was under his care. Dante Alighieri explored this issue more thoroughly in his Divine Comedy, where the traitors are placed in a deeper circle of hell than murderers, with those betraying those under their care receiving some of the harshest punishments. The Nazis had done the same by murdering millions of people under the care of their government. The second line of argument taken by the German defense lawyers was that the accused had simply been following orders. and that they would have been killed had they not so enthusiastically contributed to the Nazi war machine. This argument distinguishes itself from the earlier claim that they were not liable as individuals for their actions as state officials, as it implies that high-ranking Nazi officials such as Joseph Goebbels, Heinrich Himmler, and Adolf Hitler had intimidated them into acting as they had. The prosecutors devised a counter to this argument using a combination of deterrence theory, utilitarianism, and hard evidence. They began with the evidence. Since the German people were extremely orderly even before the manifestation of Nazism, the Third Reich kept exemplary records. Records revealed that most of the accused were well aware of their roles in the destruction of Europe and the slaughter of millions. Hermann Goering had the nerve to cheer when the prosecutors showed films of the Luftwaffe bombing cities. Alfred Jodl declared that if they had been punished for disobeying by refusing to carry out the systematic murder of Jews, that such a penalty would have been just. The prosecutors argued that Erwin Rommel had resisted Nazi orders and had not been punished. Unfortunately for the prosecution, however, the accused knew exactly what had become of Rommel. Justice Jackson followed the presentation of hard evidence against the accused with the argument that war criminals cannot and should not be allowed to hide behind their uniform in order to escape the consequences of their actions. This argument was rooted in deterrence theory, as setting such an example would in theory keep others from committing atrocities with the assurance that they could shield themselves with their nation's flag should they be brought to trial. In punishing the Nazis for what they had done in such a high-profile case, the prosecutors and jurists at Nuremberg would make clear to the world that those who committed crimes against humanity would be punished no matter the circumstance. The results of the trial were mixed. Most of the accused were sentenced to death. However, some managed reduced sentences or acquittals based on the evidence. While this may seem a partial failure, the fact that some men left the trial without an appointment with the hangman gave credence to its authenticity and veracity. Perhaps the most problematic of outcomes was that of Karl Dönitz, the commander of Germany's unrestricted submarine warfare program. Dönitz was sentenced to 10 years, as his attorney, Otto Kronzbühler, had obtained an affidavit from American Admiral Chester Nimitz stating that the United States had conducted submarine warfare in exactly the same manner as Germany. As a result, Dönitz escaped the trial with his life while tainting the reputation of the United States in the process. There are two ways of looking at Dönitz's partial victory here. Supreme Court Justice Harlan Stone and Atlantic writer Wazansky argued that the trials were merely a high-grade lynching party, and that the court's backing down in the face of evidence of wrongdoing on the part of the United States damaged the court's legitimacy. A more charitable view would hold that the court was attempting to determine the precedent that it wanted to set with regards to international law throughout the course of the trial. Nonetheless, Dönitz's argument illuminated the fact that there's a fine line between what constitutes a war crime and what constitutes mere acts of war. Overall, the Nuremberg trials were one of the most admirable and virtuous acts of the 20th century, as they solidified the concept of natural law as a legal and moral structure. The trial rejected strict positivism and moral relativism in favor of a sense of universal morality when applied to law. This is not to say that the Nuremberg trials were a solution to the century's problems, as the lack of action taken by the West to combat the genocidal horrors of communism in the Soviet Union, China, and Cambodia suggests that the lessons of the trial may have been quickly forgotten. Nonetheless, the trial stands as a monument in the condemnation of the evils of Nazi Germany, a warning to those who consider adopting hateful ideologies and principles, and as an undeniable precedent for the punishment of aggressive war and genocidal atrocities on the international stage. As the Third Reich lawyer Hans Frank stated before being hanged, 1,000 years will pass, and Germany's guilt will have not been erased.